What's going on, everybody? Chris Wagoner over at Wagoner Law, reviewing another Suits trial scene clip. I like these. Honestly, I wish there were more. It doesn't seem like there's as many of them as I thought there were. I know that Suits is more about the behind the scenes stuff, but and maybe I'll comment on some of that stuff too, because that's a real thing in litigation and in the legal world. There's a lot of most of the work happens out of court, and that includes dealing with opposing counsel and dealing with clients, dealing with other witnesses and things like that. So this is a trial that the two main characters, Harvey and Mike, are in against one another apparently, and it looks like it's another inner firm thing. But they're actually in front of a jury on this one, and let's just get right into it.
Gentlemen of the jury, every court case in history has come down to one thing: proof. And the facts of this case are
Faye Richardson fired my client without proof, and now she is making the outrageous claim that she didn't have to show cause.
even though she didn't need a reason to fire Miss Wheeler, she had one, because as anyone who's ever worked with her knows, she's a nightmare.
But not liking someone is not reason enough to steal their livelihood. And my client is not only loyal and fierce, but she is a brilliant attorney.
And they can say she's a saint all they want.
Okay. So,
But Faye Richardson,
what they're doing right here is called opening statements. Opening statements happen at the beginning of every single jury trial. You do get the option to waive opening statements, and you don't have to give one, but that would be a serious blunder because opening statement is the most important part of trial. It's the part where the jury gets to hear what's going to be happening, what they're going to be saying, the evidence that's going to be presented, and they get an idea of kind of how they want to go ahead and decide on the case at that point. Opening statement is my favorite part of trial because it's my first time to really stand up and present the evidence. I get to finally present the case that I've had for usually over a year, sometimes as many as 3 or 4 years. So it's really this like moment of relief where I can finally say what I've been wanting to say for the past couple of years. The problem with this opening statement scene that they're showing here, and most opening statement scenes that they show in TV and movies, is that they basically are making closing arguments already. You're not supposed to argue when you give your opening statements. You're supposed to say, and ladies and gentlemen of the jury, the evidence is going to show you that my client had good cause to fire, Miss Brown or whatever her name is. You can't just get in there and say and then this happened, and then that happened, and then this happened, and that's why you have to find my client guilty or not guilty or whatever it might be, because the evidence hasn't been presented yet. So it is kind of a subtle detail, but it actually does make a big difference, and it actually does matter.
Richardson deemed my client guilty and passed sentence without proof of anything. And so, ladies and gentlemen,
it is your job to keep them from getting away with it.
That is good.
Are you ready to call?
That actually is good, the way that they did that, or the way that he did that. The opening statement is a really good time to just impart upon the jury the seriousness of the situation and the power that they have, to give them the agency to make the decision, to make these tough decisions. So talking about things like, all courtroom cases have always required proof. Like, it's not a point that I would really make, but he's not wrong there. But what he's trying to do is he's trying to empower the jury to make the decision, to step up to the plate and do the right thing.
Witness.
We are, Your Honor. We call Samantha Wheeler to the stand.
All right, so he's going to call his first witness, so he's on direct.
Ms. Wheeler, when my client joined your firm, did she say if you crossed any lines, you'd be fired?
Yes. And then she fired me without any evidence.
All right, so now before he really starts getting into the questions here, direct examination is what you get to do when it's your turn to make your case. So in criminal cases, the prosecutor gets to make their case in chief first, defense will go second. So when the prosecutor's turn to call their witnesses, every witness they call, they direct, which means they don't cross-examine that person. Now, I got an issue with this because he's asking questions sitting down. Like, he should be on his feet. He needs to have his binder here needs to be up, and he needs to be interacting. He needs to be moving around and talking to the witness. It makes it more interesting for the jury. The better they're paying attention, the better paying attention they are, the more likely they are to rule in his favor.
We're not here to debate whether you crossed the line or not. Of course, knowing your reputation, you probably did.
Objection.
So he said a lot of things there, and Mike is rightfully objecting there. He was bringing character testimony. He was testifying, frankly, and then he wrapped it up with a question.
He's trying to bias the jury because his client didn't have cause and they know it.
All right.
Well,
So this is another mistake that you see in TV a lot also is he makes the objection and then he says the reason for the objection, but not just, he doesn't just say like objection, leading, objection, compound question. He's actually saying, oh, he's trying to bias the jury so that this and that and the other thing happens. You don't make those arguments in front of the jury. What happens in those situations is you say objection, you state the grounds like, irrelevant, compound, asked and answered, whatever it might be. And then you ask the judge to approach, and you literally will go up in front of the judge, and the judge will push a button that will make a sound in the courtroom so that the jury can't hear you talk, and you'll hash out all this stuff off the record, and then the judge will make a ruling.
let's talk about cause. Ms. Wheeler, the day you met,
Like here, the
did you
judge
tell my
didn't even
client to go
rule.
to
Like
hell?
the judge would have to make a ruling.
She had just stripped my mentor's name off the wall, and I was...
In that very same meeting, did you threaten to find something and use it against her?
You're making it sound worse than it was.
Am I? You were defiant, openly hostile on her very first day in front of the firm's
All right,
leadership.
so where are those facts coming from? She's defiant. She's openly hostile. You were doing this on the first day. He's testifying. He's bringing in facts that she hasn't talked about. And as far as I can tell, this was the first witness called after their opening statement. So no one else has talked about these facts. You can't ask those. I mean, he could ask those questions, but there's no basis for asking those questions. So it's a poorly worded question, and it's also in the wrong time.
Is that not true?
Yes, it is, but
In fact, haven't you had numerous dust-ups with every single member of the firm's leadership?
having conflict doesn't mean...
That you're
So again, where are these facts coming from? They're coming from the attorney. That's the problem here. Without any other evidence to support his questions, the jury has no basis for understanding what he's talking about. Like, what does he even mean by a dust up? You could object to it. You could object to ambiguous. What a dust up is to that attorney isn't what a dust up is to me, isn't what a dust up is to you, isn't what a dust up is to the witness or any of the jury members. There's multiple interpretations of what a dust up might be. So if I'm the attorney that's listening to this guy ask questions, I'm going to object and say ambiguous. Probably going to get that sustained as well. So without some definition of dust up, he's not going to be able to continue on with that line of questioning.
willful, argumentative, refuse to follow orders. Yes, it does, and I think it's a pattern.
All right, so who cares what he thinks? Who cares what this attorney thinks? At this point in the game, it only matters what he thinks at the end of the trial, when he's doing his closing arguments, like I was talking about earlier. When you get to the very end and all the evidence is in, then you can say what you think. But the issue is that, frankly, it also doesn't really, even at that point, it doesn't matter what the attorney thinks. It matters what the jury thinks. And again, none of these facts that he's listing have been stated by anybody. So while she has an idea, she clearly knows what he's talking about because they apparently know each other from the firm and all that stuff, which brings in conflicts of interest as well. As that's a problem there. And that he's likely a witness to these events. So how could he even be the attorney in this case? Because he could be a witness, So the fact that he was there and saw all these things, he was privy to, these dust ups, her behavior in the office, which is what, theoretically led to her being fired, would preclude him from being the attorney of record because he knows, or he could be called as a witness.
It's ridiculous.
Is it ridiculous that last year you tried to induce me into an illegal plan to put away a mugger?
Your mugger. And I didn't follow through with it.
No, you just threatened to have the man's daughter taken away right
So how is
before
this
you
relevant to
slugged
what
him
we're
in the
talking
face.
about?
I did all of that for you.
I didn't tell you to assault him, and I'm not the one who's on trial here.
Objection. Neither is my client.
He's
No,
testifying.
she's just untrustworthy, insubordinate, and anyone who's ever worked with Samantha
These are all
Wheeler would want to
conclusions.
fire her.
Your Honor, he's testifying.
Mr. Lipp?
No, I'm saying poison like her should be ripped from its root, just like my client did for the good of this firm.
Your
Right.
Honor.
Okay. So great objection as the testimony, but now you got to move for mistrial because he's just coming up with all these conclusions. No, she's, poisonous, terrible, horrible, no good, very bad. Like those are all conclusions. And so him also letting the jury know that they have this prior relationship, the two of them together, apparently to induce illegal activity. All of that normally would be handled prior to the trial. I mean, this is such a ridiculous situation that it's hard to really like break it down because it's so wrong. Realistically, the fact that he is clearly a fact witness in this case, he should not be the attorney that is prosecuting her. They should have hired outside counsel to handle it, and then he could be vetted as a witness. So he would be called in this case, right? He'd be called to lay the foundation that she is all these things. She's vindictive. She's vengeful. She's terrible. She engages in illegal activity. She's attempted to induce other members of the firm to engage in illegal activity. These are all the reasons why we had to fire her. These were the good faith reasons why we had to fire her. He needs to sit down as a witness and testify to those things. Just because you're an attorney doesn't mean that you can. It's actually the opposite. Because you're an attorney, you can't actually add facts into the case. All you can do is amalgamate the facts together and then explain to the jury why it is that your interpretation of the facts is the one that is just and right in the situation. They should find in your favor. So he shouldn't be there in any way, shape, or form. He should not be the attorney. He should be a witness.
Mr. Litt, that's enough.
I agree. We've all had enough of Samantha Wheeler.
Look, that's not a question. I agree. We've all had enough of Samantha Wheeler. Who's we? Him and the jury? They don't even know her. Like, this was a terrible example of a direct examination. It wasn't handled very well by Mike over here. He he should have. I mean, at this moment right now, he should move for a mistrial, and they got to start all the way over again. But frankly, he and they, both sides really, but Mike specifically, because he's the opposing counsel here, they should have handled these issues earlier in the trial. Earlier in the day before trial began. You can handle all these evidentiary issues before you get into trial. You can say, listen, we know that, this attorney right here, they have a prior relationship. We've discussed it. We don't think that it's going to be an issue. We're going to allow it to go forward, but he's not going to talk about their prior relationship. He's not going to talk about any potential illegal activities. He's not going to talk about all these different things. And that if he does talk about those things, then we're going to get an automatic mistrial. You can do that. And the judge can actually put that on the books and order that that's the case so that you can avoid this specific issue. Hey guys, it's another clip of me reviewing Suits. This was a bad one. The others weren't quite so ridiculous. But hey, it makes for good TV. So if you liked what you saw, leave me a like or give me a subscribe.